Cool.
Good day. How long does a debtor have after sale of execution to salvage the property with full outstanding amount? If this is legally possible, can you please advise Rule 46 capital A, subsection 9, was handed down 17 January 2022.
Okay.
Go, Bruno.
Nice. So 46A deals with the sale of immovable properties through the High Court. Subsection 9, it was basically something that was introduced in order to make provision for reserve prices. Our sale and execution laws a couple of years back were still very open. Properties, the court had a discretion on how the sale was supposed to take place, but never was it necessary to actually have a reserve price set. Due to some abuses around certain jurisdictions, the rules came out with a provision requiring now the courts to approve a reserve price. All this effectively means is now if a bank wants to foreclose, in addition to the number of hurdles that they need to go through to sell the property, one further hurdle is that they need to do valuations, bring it to the court's attention, and ask for a reasonable price, ask the court to set a reasonable price, bearing in mind that because it's a forced sale, one normally doesn't expect to get full market value. So, you know, a typical rule of thumb is 100% less 20 or 30, right? On a side note, as a matter of opinion, this is causing quite a bit of backlog and a bottleneck, I found, because the courts don't know how to deal with the purchase prices. The valuations don't always take into account the difficulties that people might experience with particular properties, meaning that I've seen properties go back on auction 3-4 times. Constantly, the banks having to go back to the court, say, oh, well, it didn't work. Please approve. Please approve. I have seen recently a practice is to go to the court with the highest bidder, even if it was under reserve, and ask the court for leave, just to allow the sale to go ahead, and just to prove that this was the highest price attainable. It's not that bad. It would be justifiable to just let it go as opposed to having it placed on auction again. Anyway, so now going back, the tough part of this question is, how long does a debtor have to repay to basically repay and salvage the property? Now, the National Credit Act under 129 specifically speaks, has a specific clause that at any given point, the debtor can go and settle the debt with costs, and thus the sale needs to be stopped, and nothing will happen after that. The interesting thing, and we actually did a court case about this about 2 years back, but the client didn't go ahead with instructions. There was a level of ambiguity as to when exactly this tender could be made to salvage the property. So there is a case that went into it, but referred to a different section, and basically said that if a person settles the debt at any point before transfer, it's perfectly fine. They can salvage the property. After transfer is too late. So, but I think that's acceptable. After transfer is too late. Any time before transfer is acceptable. But the court didn't actually address the particular section that I was working on, which in the execution context, especially when it comes to immovable property, where you have a sale and 3 months later you have a transfer, and that's what one needs to look at. So it's not as simple as, here's an asset, we sell and transfer it immediately by exchanging it. This takes a 3-month process, and this particular section that I was focusing on basically said that if the property is sold, irrespective of whether it's been transferred or not, the initial sale, if that's been dealt with, you shouldn't be able to settle, basically make the tender and salvage the property. So there's two schools of thought, but the predominant one, because that case came out, is that anytime before transfer, you've got the opportunity of covering the bank plus costs if you make that tender the bank has to accept it and stop the transfer from going through. Incidentally, just as a point of interest, if anyone actually cares, there were a lot of investors.
Okay.
Nice, thank you. There were a lot of investors that are making use of this by approaching the debtors after the sale and execution, changing the offer, making a secondary offer, obviously taking into account things like evictions and rates and stuff. And then if they had a cash purchase, actually going to the bank and making that tender, thus negating the sale and execution. And that's where my case arose from, because it was my client on auction versus this guy after the auction making a tender to the bank to like a cash tender to the bank.
That is interesting.
Yeah,
we should have this conversation over lunch, because there's quite a few elements to that, and I think we're going to bore our viewers. But it's actually a very interesting question if that would be slightly contra bonum mores or no. That's an interesting one.
It's the wording of the act which makes it a problem. So we were with SCs. That's why I have no issue saying this. SCs was going to go to the NCA. So our argument was that unfortunately the court erred in how it dealt with the previous case, because it made a finding based on a specific subsection that shouldn't have been applicable. It was actually another subsection that applied. And in that other subsection, my interpretation seems to be right, because they use specifically the word sale. And if you look at the rest of the act, they use different wording, implying that the act is distinguished between what a sale is and what an actual transfer or delivery is. But yeah, so that's the technical side. So
yeah, it's because it's an interesting one. I mean, if you look at the in my kids' words, the OG sale and execution case, YAFTA. I mean, YAFTA makes it clear up to the point of transfer. The owner's right is only limited, but he still has the right of ownership. But exactly, but a limited right of occupation of ownership. But if you are a bona fide purchaser at an auction, to now be a third party popping in from the side, that feel, I must say, but I'm Ubuntu Bobby, so I must say Ubuntu was.
The third party is the effect, but it's not the third party's rights that are being protected.
Yeah.
So it's the equivalent of your property going on auction, me coming to you and saying, Cilna, tell you what, I've got R1,000,000 for you. So here's R1,000,000. And money never changes hands. So we do things in terms of guarantees. So here's R1,000,000 in my bank account. I guarantee you I'll buy this property from you. All you're going to do is you're going to take this guarantee, you're going to reword it and say, oh, here's a guarantee from me tendering the R1,000,000 to the bank. So the third party has no rights in terms of the National Credit Act, sure. But if I'm giving money to the debtor, I'm giving him the ability to exercise rights against the bona fide purchaser who bought the property, who spent, and and my argument is there's a void, because what happens to that sale? The act doesn't speak about the sale being cancelled or terminated or there being restitution. There's a huge kind of anomaly on what happens to the bona fide purchaser. The sale just disappears, like up and gone. Doesn't make sense.
It doesn't make sense.